to the Compliance Kitchen. Today I want to take a look at a recent DOJ press release. This is in regards to a settlement with Gap Inc. They resolved claims that Gap violated law by discriminating against non-US citizens working for the company. So the DOJ release tells us that it was alleged that Gap discriminated against non-US citizens, and by this we mean including lawful permanent residents, refugees, and asylees, and also naturalized US citizens because of their immigration status. So the DOJ found that Gap discriminated against workers by re-verifying their permission to work, even though there was no legal reason to do so. The DOJ also determined that Gap discriminated against some non-US citizens because of their immigration status by requesting that they provide specific documents to confirm that they still had permission to work. So as part of this settlement, Gap will pay $73,000 and some change in civil penalties. They will provide back wages to an asylee and a lawful permanent resident who lost work because of Gap's practices. And they will train thousands of employees nationwide and ensure that its electronic programs are compliant with applicable rules. These are programs that have to do with employment verification and be subject to monitoring and reporting requirements. So a little bit of a legal background here. So legally, employers in the United States are prohibited from unnecessarily verifying or re-verifying a worker's permission to work, or specifying what kind of documentation a worker is allowed to bring to prove their permission to work, if this is because of their citizenship, immigration status, or national origin. So in other words, the applicable forms that an employer uses for these verification purposes allow for several different documents that can be used to prove legal status, and the employer has to allow the worker to present whichever document the worker chooses, as long as it's one of the documents on the list on the form. So the employer cannot dictate which document to bring. And according to the DOJ's press release and the settlement agreement, this is what Gap was doing. So also the release tells us that in the past 5 years alone, the Immigrant and Employee Rights section has reached more than 100 settlements to resolve discrimination claims under the INA, or Immigration and Nationality Act. And they give us some examples of the recent enforcement with links. If you guys want to take a look at that, I have the links on the website. So the examples they gave us would be employers who refuse to hire non-US citizens because of their immigration status, employers who disqualified workers from consideration based on their national origin, rejections of US workers due to a preference for temporary visa holders, and also an example of retaliation against workers who asserted their legal rights. And you may recall that we had a recent post in the Compliance Kitchen on Facebook settlement with the DOJ, and they resolved claims that Facebook discriminated against US workers, again including US citizens, green card holders, and so forth, because it had a hiring preference for temporary visa holders for certain positions. So if you want to revisit that post, I have that also on the website, and we also have a podcast episode on that. So over the last 5 years, according to the DOJ press release, legal enforcement by the government resulted in over $11.5 million in back pay for discrimination victims under the Immigration and Nationality Act, or INA. So again, this is a quick summary, but if you want to take a deeper dive into this, I have all the links available on compliancekitchen.com.